Hello and welcome to another edition of Questions for Lawyers, sponsored by Adelman Injury Law. I'm Jeff Adelman, your host. Today, we have Jason Lazarus with us from Synergy Settlement Solutions. Jason is an attorney that works specifically on healthcare liens, getting them reduced, making sure there's nothing out there that's going to come out and bite you a few months later after you get a settlement. And it's incredibly important. And he recently wrote a book, The Art of Settlement, which I would recommend to any personal injury attorney out there to make sure that you are protecting your client's rights. We have a lot of things to go over, Jason, but I really appreciate you being here with us today.
Thanks for having me. Very much appreciate it.
Can you tell everybody a little bit about your practice?
Yeah, I've got a really unique niche and have developed a national practice working with trial lawyers all across the country when they're dealing with the complexities that they face after they settle the case. And that's all about that is what the book details. It's trying to develop the awareness for trial lawyers about the issues and ultimately, really to make sure that the clients aren't impacted negatively about different aspects that can, sometimes get overlooked and wind up causing a problem for the injury victim down the line. Could be Medicare compliance, could be Medicaid, could be ERISA plans that are trying to get parts of their recovery, could be the management of their recovery, all sorts of issues like that.
Well, and also I noticed you're dressed for Halloween today. Who are you today?
It's my lame attempt to be Mick Jagger. I've got the Rolling Stones tee and I've got my black jacket and some sunglasses. Our team, we've got a good chunk of them in the office, so there's basically a Halloween party going on today. So yeah, this is not my normal lawyer attire, but it's appropriate for the day.
Absolutely. Happy Halloween.
Yes.
Well, you mentioned ERISA, Medicare. I know you work with Medicaid. You have a hearing later today. I don't think that a lot of people understand that when you have a personal injury case and you have some type of healthcare coverage, that they need to get paid back most of the time.
Yeah. Subrogation is a massive industry. Even Medicaid, for example, in Florida, Conduit is a for-profit company that does the recovery work on behalf of Medicaid. So you have that kind of huge industry that is out there trying to collect on behalf of plans. So for ERISA plans, you've got companies like Rawlings and Conduit. These are companies that are for-profit companies that they get paid based on how much they're able to recover out of a personal injury settlement. So, whether it's Medicare, whether it's Medicaid, whether it's ERISA, FEBA, which is one of the largest healthcare plans out there because it covers all the federal employees. These programs, want to recover money out of the settlement, and ultimately the thing for trial lawyers and the injury victims to understand is there are techniques that can be used to lessen or completely waive those recovery rights that these plans have. And that's part of what is the focus of the book, is talking about these different plans and government benefits and explaining their recovery rights and the leverage points ultimately that can help get those liens reduced. Because at least from my perspective, I'm sure yours too, we'd rather see the injury victim wind up with a lot more money in their pocket to care for themselves versus it going to the government or a ERISA plan or some other type of plan.
Let me ask you this. From the perspective of an injury victim and a personal injury attorney, what happens if you ignore those liens?
Yeah, there's a multitude of bad things that can happen, from the Department of Justice coming after you. If it's Medicare, Medicaid can assert its rights pretty strongly as well, and that varies state to state. These ERISA plans will sue your client. They'll, try to deny benefits. Medicare Advantage plans, which are different from Medicare itself, they have a mechanism to sue for double the lien amount, and they can go after the personal injury attorney, they can go after the insurance carrier, they can go after the injury victim themselves for double the lien amount. And in the 11th Circuit, there's case law that supports that. That's the Humana versus Western Heritage case. So there's so much exposure for trial lawyers and their practices in terms of these liens and handling them correctly. And then for the injury victim, it's it's an issue that they don't want to be caught up in somebody coming after them after the fact. And so, I don't think there's too many lawyers out there that are ignoring liens, but what happens is they might not know the nuance. Say they might not understand that you can do a 1024B4 request to an ERISA plan and create leverage because they don't want to respond and give you all the documents you want, and there's penalties associated with it. That's something that most lawyers don't know because this is not their area of expertise. A trial lawyer's job is to zealously represent their client and recover the money for their injuries and damages, and expecting a trial lawyer to know all the nuances of ERISA or Medicare or Medicaid. I wrote a 200-page overview of these issues. It's complex stuff. And, so the problem really ultimately is that if you don't have that area of expertise, you can make a mistake, which can ultimately wind up coming to bite the trial lawyer in terms of malpractice liability and exposure, and ultimately impact the injury victim.
Yeah, and a lot of clients that I deal with as a personal injury lawyer, I tell them your health insurance needs to get paid back, or Medicare needs to get paid back. And they go, well, why do they need to get paid back? Can you explain a little bit about that, why this exists?
Well, the theory is that if you recover money as a result of an accident that a third party has caused you harm, and ultimately they're paying you back for some of your medical damages, that the government or insurance carrier says, well, we should get money back in that scenario because we're paying for something that someone else caused. It's not like, you get sick and you go to the hospital. This is specifically, hey, you got hurt, we paid money on your behalf that someone else caused you harm and ultimately is compensating you for that, and you're receiving monies for past medicals. When you make a demand, part of your demand is for past medical expenses. So the government's position or the insurance carrier's position, and they obviously either do it by statute or by contract, assert their right to recovery based on those principles. It's just an area that's developed over time, and some of these plans have very strong rights under federal law, like ERISA plans. There's some really tough Supreme Court opinions for the plaintiff to overcome, and same thing with FEBA. You've got the Neville's case. The Medicare has very strong recovery rights under the Medicare Secondary Repair Act. Medicaid is, third-party liability statutes that vary state to state, but then there's, some limitations under federal law in terms of what they can recover. So, it is an area of law that, is quite well developed.
Well, I think that kind of what you're saying is whoever is paid out the medical bills sits back and goes, hey, we don't want you to get paid for what we paid out. You're double dipping. Right. So that's where somebody like you comes in. But when somebody hires an attorney like you, and usually it would be the plaintiff's attorney, you're not paying usually dollar for dollar what the lien holder is asking for. Am I right?
Yeah, absolutely. There's a lot of arguments, and it depends on who the lien holder is. So, for example, Medicare has waiver and compromise processes where you can make the normal arguments you would make to a lien holder that, hey, my client is not being made whole. That's there's a legal doctrine out there called the made whole doctrine. My client is only getting a portion of their full damages. So you as a lien holder should only take a similar portion of what your lien amount is. So with Medicare, you can't make those arguments through their normal process because there's a formula and you just apply that formula. But then there is a waiver and compromise process that you can make those kinds of arguments. And that's what we do, is we will make those arguments. And for example, you mentioned this Medicaid hearing. So what I do with those is I go in front of an administrative law judge and argue that Medicaid should get less than they want because of this U.S. Supreme Court case called Adelman. And that's based on equitable principles, that made whole type of idea of, hey, client had, $30 million in damages, but only recovered $3 million. So therefore, that should be the cap on all damages, should be that ratio, that percentage that it creates.
Understood. And basically, who needs your services? Who would you recommend? Again, if somebody were asking you, what's the type of person that would hire you? Who are most of your clients?
Well, in the lien resolution area, and we do some other things. We do Medicare compliance, we do planning for the injury victim themselves and their recovery. So it does sort of vary depending on what exactly we're doing. In the lien resolution context, it's typically trial lawyers, and they're hiring our group to, at the end of the day, one, make sure that their client gets the best possible result, two, alleviate their staff from trying to do something that perhaps they don't have the training and background to do, and potentially could make a mistake there. And, also to ultimately, in most states, that the expense of hiring a lien resolution expert is passed along just like other case costs. So it is a profitability issue for the law firm as well. But typically it's law firms are hiring our lien resolution group basically to be an outsourced partner and have us take on the responsibility and the liability ultimately for making sure that those liens get resolved in a compliant manner and get the best possible result based on what the law will yield.
Jason, everybody who is listening to this, especially injury lawyers, at the end of the day, they want to know, what does it cost for a service like yours to get involved? How do you get paid?
Yeah, so trial lawyers will understand this. We only get paid if we save money off of the lien amount. So we take a percentage of what we save. It's 15% of savings. So, for most injury victims, it's sort of a no-brainer, right? I mean, they're only going to pay us if we're able to get that lien reduced. It's part of the foundation of the company. We only want to be involved if we're going to make that person better off, if we're going to improve their life somehow, some way. We have that same mission that I think most trial lawyers do, which is you're trying to do good. You're trying to make sure ultimately that you're helping that client out to the best of your ability, and you get paid out of what you recover. And we're aligned, and we do the same thing. And we want to make sure that our people are incentivized to get the best possible recovery. So that whole team is bonus based on how much they can save off of the lien amount. So we our goal ultimately is to get that lien wiped out. Do we always get that? No, because that may not be in the cards, but that really is the end goal, is to get that lien reduced as much as possible to put more money into the injury victim's pocket.
Well, from personal experience, dealing with Medicare is no picnic. How do you how do you deal with Medicare when somebody hires you to work on a case? How is it that you get them to be responsive? Because I find in my practice, it's impossible sometimes to get a timely response to a request for a lien.
Yeah, I mean, Medicare is an animal unto its own, and I mean, what happens is we have so many cases that we're dealing with Medicare that we do get responses, and we do have people that will just sit on the phone because that's what their job is to do. Medicare, we don't necessarily shorten the time frames because Medicare has time frames under the Medicare Secondary Payer Act that they don't accelerate. But typically what we're able to do is get a lot of that unrelated care pulled off before they issue a final demand, and then once they issue the final demand, then we can work on getting a compromise or complete waiver of that Medicare conditional payment, which is a very successful part of what we do is getting those completely waived. And we've got them waived in 6-figure conditional payments and 7-figure recoveries. There's ways to deal with Medicare, and you have to know those ways and become an expert in that. And that's what we do. That's all we do. We have people that all they do is deal with Medicare on a daily basis, and they know the process to get that end result.
So you explained how you get paid, and you've explained sort of your process, your protocols for getting involved. Somebody out there, personal injury lawyer, has a client with a large Medicare lien or Medicaid lien, and unfortunately the settlement proceeds, maybe the policy limits are not a lot. Tell us why they should hire Synergy as opposed to trying to do it themselves.
I mean, it really goes back to, what I said earlier is, I mean, for most trial lawyers to keep up to date on all the nuances and changes in the law, whether it's Medicare, whether it's ERISA, Medicaid, FEBA, whatever, military, it is almost impossible. And the time that is spent really should be allocated to pushing the next case further to conclusion versus spending time after the case is resolved. And it's sort of like, think about it this way. You could do probate in a state, you could do guardianship. There's a myriad of things that are done that are part of a personal injury case that a trial lawyer could do, but they don't do because there are lawyers that specialize in that area because it is specialized, and it is a better allocation of time and resources to have the expert do it because that's what they do day in, day out. And this is absolutely no different. And part of what our messaging on this is, it's about educating law firms and lawyers about why it just doesn't make sense not to have experts dealing with this particular aspect. Traditionally, it's been something that personal injury law firms have done for clients, but that doesn't necessarily mean it's the best way to do it. And if there's a better way to do it that creates a better outcome for the client and a better outcome for the law firm, it becomes a no-brainer. And this is really an area that I believe very, very strongly about. Obviously, I have a business interest in that, but if you look at, the fact that Medicare now has the DOJ going after law firms and, getting monetary settlements and requiring compliance programs in those law firms, and you've got Medicare Advantage plans that are suing law firms for double the lien amount. You've got ERISA plans that are incredibly aggressive about their recovery rights, FEBA plans. It just really doesn't make sense for most law firms, and it doesn't make sense for the injury victim because they're probably not going to net out as much as they should if they had experts that's all they do is deal with these issues.
Well, I can tell you that there's nothing that quite makes my stomach drop more than getting a Medicare letter after I've settled the case and just having to deal with that whole mess, whether maybe a client didn't tell me about it or something like that, and then we have to deal with it. So again, to have somebody like you involved from the beginning, I can't say enough how important that can prove to be. We could probably talk forever about this, but I would be remiss if I didn't get into the issues of a personal injury victim who is already on some sort of disability and your involvement with that. Can you explain for anybody watching, listening, how important it is to consider the person's Social Security benefits or disability benefits when they're getting money from a settlement that has nothing to do with that?
Yeah, I mean, that's an area that I deal with, day in, day out in my law practice. I've got a law practice that's separate from Synergy, and my primary area of practice is advising clients about keeping their government assistance programs intact, particularly disability-based programs when they settle their case. And what most clients don't understand is if they're on a Social Security benefit that is needs-based, that program is going to have a very small asset cap. So for someone that's single, it's $2,000. If they're married, it's $3,000. So they could have a very small settlement, say 10 grand net, and they've just lost their government assistance programs because they're going to be over the asset cap. And then in turn, if they're on SSI, which is the needs-based Social Security benefit, and they get Medicaid, well, the SSI is tied to Medicaid. You lose the SSI. The client might say, I don't care. My SSI payment's a couple $100 a month. I don't need that. I'm getting 10 grand. But what they don't realize is at the same time, they've just lost Medicaid. And so, understanding the impact is really, ultimately what I do a lot of is explaining that to clients and letting the client ultimately make an informed decision about what to do. And there are things that they could do aside from setting up a special needs trust, which is a way to shelter a settlement from being countable. They could spend the money down, they could buy a house, they could buy a car. Those are all exempt assets. There's a lot of different ways to come at it. But the problem is that most clients, they might not get that advice, or they might not know to say anything. And so it's really important, for a trial lawyer to be talking to their client, to know the differences between these benefits like Social Security, disability, SSD, and Medicare. Those are not impacted by the settlement. Medicare potentially can be impacted. That's the whole Medicare set aside issue, which would be a very long conversation that we don't want to have today. But generally speaking, those are entitlements. It's critical that lawyers be able to differentiate between the entitlements and those that are needs-based benefits, so the client understands the impact. So if they're getting food stamps, they're getting housing subsidies, Medicaid, SSI, those are all things that are going to be impacted by the receipt of the settlement. So you've got to make sure that they understand that there's that potential impact and loss of those benefits.
That's critical. I mean, losing that type of a benefit in many cases makes it not even worth it to get a settlement.
Correct. I mean, and it could be devastating for the client if they don't understand that, and then all of a sudden, in turn, they lose their benefits. And there's most certainly, malpractice risk for lawyers for failing to advise them, and that's where they've got to bring in experts like me, someone that they work with regularly, to advise that client and or make sure that they understand it sufficiently that they can explain it. I mean, that's one of the things in the book that I talk about, is this idea that there's a lot of issues that are of the law that are present when you're settling a case for someone that's disabled. And so the trial lawyer has to explain those so that the client can make an informed decision and or have experts come in and explain those issues. Same thing like with Medicare, I alluded to that, but if a client's on Medicare, they really need to understand that there's some risks out there because of the Medicare Secondary Payer Act. And I think a lot of those issues get overlooked because there's not been a lot of enforcement on the Medicare Secondary Payer Act, but it still remains an area of liability and potential problems for the client, particularly now with, every settlement of $750 or more gets reported to Medicare by the insurers, and there's a lot of information that they get in turn. So it's, all the government benefit programs really now have some duties and obligations for trial lawyers to explain those matters to their clients.
Well, for anybody who hasn't, picked up your book, I actually, read it, and I'm so glad that, I remember when you had your cycling accident, and you went through quite a time, and you unique perspective dealing with some of these issues, what you had done before and what you had actually experienced after your horrific accident. That I'm so glad you're doing okay. But can you tell us a little bit about your experience going through a trauma like that and then seeing all of this go into action?
Yeah, I mean, having been in this field for 20 years, you really don't truly understand until you wind up in that situation yourself and have to experience every aspect of it. For me, waking up in a level 1 trauma center, not knowing where I was, having tubes shoved down my throat, not being able to speak because my jaw was wired shut, and you know being scared. I mean, waking up in the ICU is a scary proposition. And going through from that, transitioning to a bit of recovery, and then getting involved in the litigation surrounding my case, ultimately, having the case be mediated and sitting in a mediation for myself versus, having been a participant and seen families and people struggle with, what had happened to them. I sat across from the person that, was careless and hit me with their car, and, participated in a process that, I had seen many times from the outside, but had never obviously experienced it myself. And, all of that was certainly eye-opening, and it was tough to deal with, even having my experience and having my team here. It was difficult. And then ultimately, dealing with the issues of what to do with the recovery. I negotiated my own lien with United Healthcare, and I mean, so I went through everything that our clients go through, and for me, it was enlightening, and also it now allows me to tell everyone that's part of our team about the importance of who we serve and what we do and why it's so important. And I do it through the lens of, here's what happened to me, and I was lucky. I got hurt pretty badly, but I didn't have a brain injury. I didn't become paralyzed and or killed. I mean, and many of the people that we deal with have had such horrific, tragic things happen to them. And I always want our team to understand the importance of who we serve and our mission of improving those people's lives and making sure that we do everything possible to get the best outcome for those people. Because having experienced it myself, I know how difficult it was just for me, and I certainly had every advantage in that process, having the experiences that I had in the past.
Well, again, I mean, I knew you before any of that happened, and I knew your expertise, but to go through it, like you said, there's no experience like firsthand experience. I'm sorry you actually had that, but I know that it certainly does help you understand the plight of our clients and your clients even more. Can you tell me a little bit about some of the legal and civic organizations that you're a part of?
Yeah, I mean, I'm very active in a lot of the different trial lawyer associations. Just, I'm part of the AAJ, FJ, which is the Florida Justice Association, and also part of a bunch of professional organizations that are related to what I do. For example, special needs planning, which is the Academy of Special Needs Planners, and also Medicare. We've got a whole group that's dedicated to working with the Medicare Secondary Payer Act that I'm a part of. That's one of the areas that I'm certified in. And then locally, I'm involved with a number of charities here. I'm actually chair of the ADA's Tour de Cure, which is a cycling event that raises money for diabetes, and part of the Fane House, which is a phenomenal local organization that helps kids that age out of the foster system so that they have a place to learn life skills and be successful. Actually, the proceeds from the sale of the book are all going to the Fane House, because it's such a great thing and there's nothing like it. And I just love the idea of giving those kids a shot at being successful in life, because they've had such a hard time coming out of that system.
I think that's absolutely wonderful, Jason, that you do that, giving the proceeds of your book which again can be purchased for those of you who are interested and can see on the screen, can be purchased right through Amazon on Kindle, hardcover, paperback, and I certainly would highly recommend you look it up, The Art of Settlement by Jason Lazarus. Jason, one of the things that I really appreciate about you is that, and your office in general, if I have a question, you guys get right on the phone. You tell me, look, do this. You may not need me yet, but for those who are listening, watching, tell us what's the best way for us to get in touch with you?
So, I mean, on the web, synergysettlements.com. I do a lot of, like you said, talking to lawyers about these issues. So you can always reach out to me directly. It's jason@synergysettlements.com. Our business model really is that of supporting trial lawyers. So, a lot of that is doing consultations, helping walk through issues, because we may not be necessary at that point, but we know too that providing that information and educating the lawyers is ultimately going to help them and help the end client. And at the end of the day, at some point, they're going to come back and work with us, which is really what the end goal is.
Well, Jason, thanks so much for taking the time to speak with me and to educate us about what it is you do. And I think anybody who is watching this can understand how important that is. So again, I greatly thank you for that. I'll be putting your information on the post in terms of the website, phone number. What's your phone number also?
It's 877-242-0022.
I'll be putting all that on the post. Just want to remind all of you listening, watching, if you haven't heard, there is an election going on November 3rd, Tuesday, next week. In Florida, early voting concludes on Sunday. If you need any information about voting, where your precinct is, any questions about voting, you can always go to 866-OUR-VOTE. It's a nonpartisan organization. Also, 866-OUR-VOTE.org. I'm volunteering for that organization and very proud of that. And again, I've spoken with Democrats, Republicans. It is a nonpartisan organization designed to tell people where they have to go. So again, I'm just reminding everyone that there is an election in case you did not know on Tuesday next week. And I encourage you to exercise your civic duty and cast a vote for the candidate of your choice. Jason, thank you so much. And we will have to do this again at another time for sure.
Absolutely. My pleasure. And get out and vote.
Absolutely. If you have any questions for me after the show, I can be reached on Twitter at Jeff Adelman. And you can always email me, jeff@adelmanlawyers.com. Thank you, everyone. Be well.